District Court of the State of Nevada is now in session. The Honorable Dixie Grossman presiding.
Thank you. Please be seated. All right. Welcome. We're on the record in this matter. Council, just as a little agenda, pursuant to the order, we're going to address the electronic media coverage rules first. Then I'm going to move into, I have a correction to the record. We'll deal with witnesses, motion in limine, and then finally we'll get to the housekeeping matters that we normally take at the beginning of the trials. Any objection to that agenda, Mr. King or Mr. Cooper? Okay. So as to the electronic media coverage, I am informed that we have our Nevada judges. We have 775 times, and we have Nevada Signal. My understanding, and press, feel free to correct me if I'm wrong, 775 times and Nevada Signal are here solely for paper reporting. Is that correct?
Yes, ma'am.
Thank you very much. So they don't qualify as electronic coverage. They're not asking to have a photographer in the courtroom, so they wouldn't fall under those rules. The only member of the press today that falls under our electronic coverage rules would be our Nevada judges pursuant to their order. Is there anyone who wishes to note anything for the record before we go forward with regard to limitations under those rules today? Mr. King?
None, Your Honor.
Ms. Hardy Cooper?
Your Honor, I would just request that there be a reminder that there should be no other recording of the proceedings in here, that everyone, in the world these days has a camera phone, is capable of audio and video recording. So we'd ask that you make that ruling as well.
Okay.
There's also, we noted a photographer that was taking pictures outside, so a reminder that still photography is also not allowed into the court, except for us to Mr. Falcone and our Nevada judges.
The photography, both of you know me well enough to know that I'm going to follow the rules. With regard to the still photography inside the courtroom would not be allowed pursuant to Rule 235, subsection 3. My understanding is that under the rules, the common areas, the public areas of the courthouse are free game for any.
We understand, you seem to agree on.
Okay. Then with regard to the media request today, the presumption is that the courtroom is open pursuant to Rule 230. Press are treated the same as members of the public. So with regard to the very narrow closure order, only that section of today's trial or the trial over the next 3 days is closed. All other portions will be open. As to those sections that are open, both video and audio recording is permitted by our Nevada judges. That is the only press request that I have for electronic coverage. The limitations imposed are in accordance with the rules. In addition, just as a reminder, pursuant to Rule 239, there shall be no recording or broadcasting by audio or video any privileged conferences, including but not limited to conferences between attorneys and their clients at counsel table, between attorneys, between clients, and or between or among attorneys, their client and the judge, when the judge calls for a colloquy at the bench. No bench conferences. There will also be no recording during recesses or breaks. I do remind and admonish all of the members of the public who may be here that use of electronic devices without the permission, other than members of the court staff, I'm going to allow counsel to keep their phones at their tables. If you happen to need your phones, you're welcome to have them out. Our bailiff, the law clerks, court staff may have a cell phone on them. Members of the public, please make sure that you're not using your devices to record in any way. If you are seen on a device, you may be asked to leave, or pursuant to the rules, the phone might be confiscated. Any questions? Okay.
No.
Let's move on to the correction of the record, please. As you're all aware, I issued an order in this case with regard to the closure. In one of those sections, I indicated that Mr. had not filed a fact-specific affidavit. Mr. King, I apologize. There was one filed probably a month or many weeks later after the original motion. He did not initially respond or oppose Ms. motion. The court did order him to file an opposition, and I specifically required, pursuant to Myers versus Haskin, a fact-specific affidavit. His initial opposition did not have the affidavit again. However, Mr. King did file an amended response. It was without leave of court and with an objection from Ms. But nonetheless, I see a separate standalone filing on April 17th, 2024. Having reviewed that fact-specific declaration, just to see if in any way it would change, I look at all of the allegations. I will note that Ms. Hardy Cooper was correct. There was no fact-specific affidavit included with the opposition to motion to close, so there was no specific statement under oath disputing any of those allegations. Similarly, specific allegations included in the motion that were then renewed in the motion to close. The allegations with regard to intimidation or an intent to distribute and use public information against her, that was not specifically identified in the affidavit filed April 17th, 2024. So I stand by my ruling, but I do want that correction noted for the record. Mr. King, thank you very much for getting an affidavit on file. With regard to the court's correction of the record, anything further from either counsel for the record?
Yes, Your Honor.
Go ahead, sir.
The opposition has filed a designation of witnesses and a supplement. Nowhere in those two lists is the testimony that's already been given. And I don't believe that the opposition can unilaterally cancel that evidence from being part of the record in this dispute.
And let me clarify, I don't know that that was your intent, Ms. Hardy Cooper, but if it was, I would acknowledge the minor child's testimony stands pursuant to the prior order for alternative testimony under the Uniform Child Witness Protection Act. So that is part of the record. I will be considering it as part of today's case. Was there any other witness that you were concerned about, Mr. King?
No.
Okay, so with that caveat, Ms. Hardy Cooper, no
I
objection.
understand it, except that now.
Okay. Then moving on to the rest of the witnesses, do we have any witnesses present today in the courtroom that I need to swear in? Thank you very much, ma'am. Would you please stand and state your name for the record, just so I know who was here?
Yes, Lindsay Perkins.
Lindsay Perkins, thank you very much for being here, Ms. Perkins. Go ahead and have the seat. Counsel, do you want to swear Ms. Perkins and the parties in now and then invoke the rule of exclusion? I understand that we may have additional witnesses as they come in late, but we'll at least note who was here. Is that
Yes, ma'am.
acceptable? Okay.
Yes.
Ms. Perkins, would you be kind enough to stand? Ms. Please be kind enough to stand and raise your right hands to be sworn.
Do you and each of you solemnly affirm the evidence and testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you. Ms.
Yes.
Ms. Perkins?
Yes.
Thank you. The rule of exclusion has been invoked. Ms. Perkins, if you'd see yourself out, please do not discuss your testimony with anyone until after the close of trial. If you do happen to go somewhere, just let the front desk know if you have to go pay your meter or something, and that way we'll know where you're at. Okay, thank you very much. All right. Turning next to the motion in limine. There are 4 claims outlined. Mr. King, which, if any, are in contest today?
Well, we're not intending on offering any exhibits.
Okay, so,
We're not intending on calling in any witnesses other than my client.
Okay.
I'm not sure I've got half the list of my own client as a witness anyway.
so as to claims 1 and 2, there's no objection. Mr. doesn't intend to offer any exhibits, and there would be no preclusion on your calling your own client, but he doesn't intend to call any other witnesses,
Right.
correct?
Right.
Ms. Hardy Cooper, with that caveat, Mr. will not be offering any exhibits, and he will not be calling any other witnesses other than himself.
You know, Your Honor, quite frankly, considering the amount of rules that were disregarded in this case, I believe he is obligated to disclose any witnesses he intends to call. Now, I disclosed him as a witness and my client as a witness, and so I certainly could call him if I wish. But my position would be that he is prohibited from even calling himself because he never provided any designation of witnesses.
Do you wish to be heard, Mr. King?
I've never heard somebody try to make that argument before. This nonsense.
I've never seen anyone not file a designation of witness over a month and a half before trial.
I agree.
His trial statement also attempts to disclose him for the first time saying that he will be offering testimony. As you saw, there was not a fact-specific declaration until April 14th in this one time. So it is not clear necessarily that he was gonna offer himself as a witness. So that's our position, Your Honor.
Mr. King, anything as a final no?
I'll submit it, Your Honor.
Okay. I completely appreciate that some disregard for the rules has been evident throughout the case. And at each and every turn, I have afforded Mr. extensions of time, abilities to correct, and so I understand some of the belief that I may be bending over too far to allow Mr. to present a case given some of the violations of the rules. That said, under the case, I believe it's Bueno, but let me double check. I believe that Mr. has a right to present his case. Ms. knew or should have been on notice that he intended to oppose. His affidavit and his motion gave notice of the claims. I intend to keep him to those claims when we get to one of the other motions in limine. Pursuant to Nevada law, and I apologize, it's not Bueno, it's Blanco. Citation to counsel if you need it, 129 Nevada 723, that's a 2013 case. But in Bueno, where someone didn't engage in discovery, didn't offer up names of witnesses, didn't provide affirmative obligations, didn't comply with affirmative obligations to provide discoverable materials. The court indicated that Judge Hoskin down in Las Vegas had the discretion to limit that party's participation, clearly through the motion to limit exhibits or other witnesses. But given the fundamental constitutional issues at stake in a child custody case, that they should have still been allowed to present their case. I believe, and I can find it for you during the lunch hour, just to paper the record, I believe that there's also case law indicating that where the opposition makes clear through the affidavit that he intends to rely on testimony from himself, it was not reversible error for the court to allow it. So the objection is noted to keep your record clean in the event of an appeal. The objection is overruled and Mr. will be allowed to testify in the case. Anything further on that point from either counsel?
No, Your Honor.
Okay.
No, Your Honor.
Motion in limine, section 3. Mr. King, do you have a position with regard to the issue as to the child's counselor that you want to address on the record?
We've already lost, and you've already designated the counselor, so I don't see any point of that being relitigated.
Okay. So for the record, the way I see that issue with regard to the request to prohibit the challenge, I believe that we addressed this before, but for your record, in Mr. response filed March 21st, 2024, he noted specifically no objection to the child continuing to engage in therapy. He indicated in an opposition that he wished to have a new therapist. Although there was no motion properly made by father pursuant to the case in Kelly, the court initially noted that he would have to bring a motion. Then I believe at the April 10th, 2024 preliminary hearing, the court nonetheless authorized father, if he wished, to try the issue by consent to try to keep costs low, so he wouldn't have to file a motion, so long as he provided the names of 3 potential therapists that he wished to change the child to Mr. Attorney no later than May 21st, 2024 at 5 p.m. There's no contest that he failed to provide those names, and so it appears that he has abandoned any claim to change the child's therapist. No motion was filed, and no names of other counselors, and again, consent that the child does need to stay in counseling. So for all of those reasons, the motion in limine as to number 3 is granted, insofar as I don't believe, like Mr. King, I don't believe it was an issue for today. Anything else for your record on that claim, Ms. Hardy-Cooper?
No, Your Honor.
Anything that I said that you disagree with, Mr. King?
No.
Okay. As to the 4th claim in the motion for limine, is this even an issue, Mr. King? I don't see it as even one of the claims that has been raised, so I didn't think it was going to be an issue today.
I don't have the motion in front of me, Your Honor. What is
To
it?
prohibit introduction of evidence with regard to Washoe County School District Trustee Jeff Church that has never come up as part of this case as being relevant in any way.
Yeah,
There's no intent by Mr. to go down that. Okay. So in light of that, it certainly wasn't raised in any opposition as being relevant to today's proceedings in any manner. The request for a order in that regard is granted. There is no noted objection by Mr. King. There's an acknowledgement that there was never any intent to introduce any evidence at trial regarding that subject. So the motion in limine as to that issue is granted. Anything further with regard to the motion in limine, Ms. Hardy?
No, Your Honor.
Mr. King, anything else for the record in that vein?
Nothing, Your Honor.
Okay. Housekeeping. Do we have an exhibit list outlined for all of the parties? We have no exhibits from Mr. How many exhibits do we have on Ms. behalf? Do we have her list?
We have 25.
25? And I'm just checking the table of
26,
contents.
sorry, 26.
And Mr. King, do you have an exhibit list as well?
I have a copy of their exhibit.
Okay. So for purposes of today, Mr. King, I assume that you and council have engaged in the conference. Any agreements?
No, Your Honor, I actually reached out to Mr. King by email and received no response, so I'm not sure where we stand on these.
Mr. King,
Your Honor, we may not object to exhibit number 1. I'd ask the court to defer ruling until that witness has completed his testimony. We will be objecting to 2 through 26.
okay. And just that I'm aware, Mr. King, didn't your client cite and rely on exhibit 1 as part of his trial statement?
Yes.
So how would he be allowed to use and cite to evidence that you don't want to come in?
No, I'm just asking the court to defer. I need to hear what he's going to say. He may testify differently than what his report says.
Okay. So with that noted, at this time, there's nothing. There's 26 exhibits marked. At this time, there are no exhibits deemed in evidence. Any other housekeeping matters? Any witnesses that we need to take out of order or any specific issues with regard to time?
The only one, Your Honor, is that Dr. Cord needs to testify tomorrow afternoon.
Tomorrow afternoon, any particular time that witness needs to?
No, he's available for the whole afternoon.
Okay. Any objection to an accommodation of the expert witness for tomorrow afternoon, Mr. King?
No objection. I'd ask that he be first up in the afternoon tomorrow because I think the moving party is going to be very close to their time limit on half the hearing.
We'll see where we're at on time, but whenever Mr. Cord can get here.
Thank you, Your Honor, but I would just note, considering the fact that he doesn't have any witnesses to produce other than himself, that I ask that we not be limited to only half the time that's available, considering that's one witness.
I have to go back and look at the JAVS counsel if we have that argument, but I believe that when we set the matter for trial, that Ms. Hardy Cooper already indicated on the record the need to have additional time, and Mr. King indicated that he could do this trial in less time.
Correct.
And so, for that reason, I'm gonna have to allocate the time based upon what you all asked for. I believe the difference was between a 1-day trial and a 3-day trial, so we'll just see where it goes. But
That's my memory as well.
usually I do intend to keep it equal unless one particular counsel has asked for specific time. Then if there was that reservation made at the first hearing, I intend to honor it. I just didn't have it in my notes, so I'll have to check the JAVS recording. I invite both counsel to do the same.
There's one other witness, which would be a short witness, that is only available on Thursday morning, and that's Rachel Foster. She's out of town.
Is there a particular time on Thursday morning before Mr. King responds?
I think she's available anytime Thursday morning. My anticipation is that we'd probably be able to conclude everything after her testimony, just depending on when Mr. his testimony.
Okay. Mr. King, any objection?
No objection.
Okay. And are there any time constraints with the rest of the day's council as far as lunch hours normally being between noon and 1:30 and starting at 9 tomorrow and Thursday? Any other time constraints that I need to be aware of now?
No, Your Honor.
No, Your Honor.
Okay. There is going to be an emergency hearing on Thursday at 1 o'clock. Thursday's lunch hour, should you need it, really will be between 12 and 1:30. Although cameras may be allowed to stay set up in the courtroom, there will be a different hearing in here that one day. So on that one day, if I can't find a different courtroom, I will ask counsel just to clear your tables, but I'll make that announcement again on Thursday morning.
All right, I hear the door opening and closing behind me. I'm not sure if additional people are coming in, but if they are, could you give, unless they're court staff, could you give the reminder earlier about the?
We will try to put a notice up, but let me just say now. Closure of court hearings is governed by many rules, but one of them is also a case talking about the inherent authority of courts to manage and control courtrooms. And in that case, closing it to make sure that people can only come in during designated times is absolutely, as both counsel are aware, always been the prerogative of the court. So far, people have been very respectful. We'll put a note up reminding them about their cell phones. But if you are coming in, if it's going to cause a lot of distraction to any of the witnesses, to counsel, if you're bringing things in and out with you, if you yourself are in and out multiple times, then you may be asked at that point by one of the bailiffs or myself to stay in the lobby until the next reported break and then come in and out only during the breaks. But at this point, people have been respectful. We will put a notice up about the cell phones so that I won't have to stop court for every time we have somebody else come in, but I will try to make that admonishment during the morning recess. Anything else from either counsel? Okay. Going forward, is the moving party on the motion. It is 10:28 a.m. Ms. Hardy-Cooper, do you wish to make or waive an opening statement?
So Your Honor, I'm prepared to make an opening statement, but I also know that you are very familiar with the case and read the trial statement. So if both sides are going to waive an opening statement, I'm happy to do so. Otherwise, I'd like to make one.
Mr. King, what would you like to do, sir?
I'll accept that and waive.
Okay, then both parties waive their opening statement. Ms. Hardy-Cooper, who would you like to call as your first witness?
Your Honor, we will call Lindsay Perkins.
Lindsay Perkins,
Who's
please.
the one outside. Your Honor, does the judge pick up here? I know there's not a microphone, I'm not sure.
Deputy Rivera, would you mind getting one of the mic packs just to make sure they have a clean record? Jab should pick up, but I'm going to give you a microphone, Ms. Hardy-Cooper, in an abundance of caution. Ms. Perkins, would you mind coming right around behind that table? Coming on up here. Just just standing right there before you come in. Deputy Rivera will open that door for you. This witness was previously sworn. Go ahead.
Thank you, Your Honor. Will you please state your name for the record?
Lindsay Perkins.
Okay. And Ms. Perkins, are you here under a subpoena?
Yes.
Okay. In disclosing you as a witness, you understand that we had to provide Ms. with your address?
Yes.
Okay, and we also notified you about the possibility that there may be press involved filming your testimony?
Yes.
Okay. How do you feel about providing with your address?
Uncomfortable.
Can you speak up a little bit? 'Cause-
Oh, yeah, sorry. I'm uncomfortable with it. I intentionally made sure that he didn't have my address even when they would come up to visit.
And why is that?
Just fear.
Can you explain why you have fear?
Yeah, absolutely. Just knowing that obviously we got a divorce and it wasn't super amicable, and so I didn't want him to know where I lived.
Okay. And then, do you feel comfortable testifying knowing the fact that we have press here recording your testimony?
I'm nervous, and nobody wants to be on the internet, so or at least I don't want to be.
Fair enough. When did you meet?
July of 2012.
Okay. And were you eventually married to him?
Yes.
One moment.
Oh, sure.
Ma'am, if you'd have a step out into the lobby, we've already made the announcement regarding cell phones. You're welcome to come back in, but not use your device when you come back in the next time. Go ahead and have a step out. Go ahead at your leisure, Ms. Hardy-Cooper. My apologies.
Thank you. And did you eventually move in with Ms.?
Yes.
Okay, when was that approximately?
Officially moved in October of 2013.
Okay, and then did you eventually marry him?
Yes.
Okay. During your relationship with Mr. did you have an opportunity to meet Miss?
I did.
Okay. Did you guys have a relationship?
No.
How many times approximately did you speak during the relationship?
Less than 30,
Okay.
and it would usually be in joint settings, soccer games, just saying hello, but not conversations.
Was there any reason why you wouldn't have a bigger relationship with her?
Did not want that to happen.
Did he tell you why he divorced?
That she had an affair
Okay. How often did he talk about that?
on a regular basis, especially when we first met and started dating.
Okay. Did he call her names?
He
Objection, leading, motion to strike.
Form of the question doesn't actually call for the answer embedded within it. The objection leading is overruled. Go ahead.
Thank you. Did he call her names?
Yeah, he would call her a bitch.
Any other names that he would call her?
Nothing that I recall.
Okay. How did he express how he felt about her?
I would say had a strong dislike or hatred for her.
Okay. Anything else?
No.
Did he have any reactions with respect to contact from the?
Objection, vague.
Ms. Hurdy-Cooper, do you wish to respond?
I mean, I can be more specific. How did Mr. Respond to messages on our family list?
Depending upon the content of the message, if it was something that he didn't like, he would become irate. It really upset him.
And then how long would that irate last?
Depending upon the severity of the message and if we had at the time or not, it could be a moment in time, or it could be days, a week.
Now, when you say severity, did you look at those messages?
Sometimes, periodically, he would have me read them and read his responses.
Did you feel they were severe? From Ms. Sorry.
Oh.
Did you feel Ms. Messages were severe?
No.
Okay. But his response?
A lot of times I would help craft it a little bit more appropriately, and so if I was able to do that, I don't feel like it was as severe, but if I was not in, then yes, a lot of times he would just speak from the cuff and not really think through what he was saying.
Okay. You mentioned sometimes they were short and sometimes they were days. What would happen over the course of the days?
If we didn't have the time, there would be times where he would drink excessively
Okay. And what
over
do you mean by-
days and days. He could go through a handle of Captain Morgan in a day and a half, 2 days.
Okay. And then how was his behavior around during that time?
Well, if he was with us, I mean, he tried his best to, I would say, keep his emotions in check and make sure that we didn't see what was happening or hear what was happening. But there were definitely times that if we were having a discussion and it was getting elevated based on whatever message was sent, that I would make sure that it was within earshot that we stopped having that conversation.
Was the drinking that you described occurring while he was in his care?
He would drink from time to time. I mean, he would drink wine, he would have a cocktail. It wasn't as excessive as it was when it was not in the care.
Okay. What about experiences when Mr. would see at a soccer game?
He pretty much ignored her as much as possible. There were times we would sit on the other side of the field or further down so that he didn't have to interact with her.
How was reactions when he received Father's Day cards that she had purchased for to give to him?
He did not like that. He thought she was invading in our private life and invading in his life and didn't feel like it was appropriate. And then there were times he made comments where he was like, does she want me back? This is ridiculous. This should not be happening.
And did you agree with his beliefs?
No, I mean, at first I thought it was bizarre, but solely because I didn't have a child of my own. And then as and I really became, I was a stepmom to him and he really is a stepson to me. It seemed normal because to me, that's what a mom does, is make sure that the child is taken care of.
Did Miss also buy gifts for the gift to his dad?
I just remember cards.
Okay. Were there times that Miss had bad days?
Yes.
And what does that mean?
It would typically mean days on end, typically anywhere from 2 to 4 days of binge drinking and a lot of times he would be up in his room in bed watching TV, would come out just solely to refill his cocktail, grab another beer, smoke a bowl, whatever it was that he was doing, and then go back in his room.
And then, so, if, there during some of the bad days?
Not when they were that bad.
Okay, did you ever take away during very bad days?
There would be times when I would go to the movie theater, we would go out and do something and just leave home.
Okay. You mentioned, smoking. What kind of smoking are you referring to?
Weed.
Okay, and how often would he smoke weed?
On a very regular basis. He would, when I was home, what I would witness is at least every hour going out and probably not smoking the whole bowl, but having at least one or two puffs.
How did that affect his impairment from your perspective?
Oh, he was definitely impaired, absolutely.
And then how about with respect to drinking on the not bad days? What was his level of drinking?
Less. I mean, there would be times where at night we would share a bottle of wine. He may have a little bit more or extra on top of that, but nothing in excess as it was when he was having bad days or when Braden wasn't.
Did Mr. grow marijuana?
He did.
And how much?
At the time that I was still living there, he had, I believe, anywhere from 8 to 10 plants.
And then where were they grown?
They started out in the garage. He had lighting that they would go underneath, and then as they became large enough to plant in a pot, he would then move them outside to the side of the house.
Was he able to access them if he wanted to?
Yes,
And then how did you feel about him growing marijuana in that
it
way?
made extremely uncomfortable.
Okay, and why is that?
Just because at the time, and I don't know what the law is today, but at the time it was illegal to grow any plants if you lived within 25 miles of a dispensary, and we did.
Was his emotional state impacted by his drinking?
Objection foundation.
Objection foundation is a general objection under Nevada law. Specifics for the record, Mr. Cade?
We have no testimony giving her qualifications to render an opinion on that subject.
Ms. Hardy Cooper, do you wish to respond?
She can describe her lay impressions of how he reacted to his drinking.
So long as it was within the knowledge, based on her observations as a lay witness in accordance with NRS Chapter 50, it's allowed. The objection is overruled. Go ahead.
Do you believe his emotional state was affected by his drinking?
Yes.
And how so?
He became more irritable, quicker to escalate voice, get in an argument.
Does he have a temper?
Yes.
How did he express his temper with respect to you?
A lot of escalated voice, yelling, screaming, just would berate me. For me, I would close up and stop communicating, just because it made me really uncomfortable. A lot of times I would just get up and leave the room. I didn't know what his reaction was, sorry.
Okay, go ahead and finish, I'm sorry. Did he ever call you names?
Yeah, he would tell me that I was overweight, that I was fat.
Anything else?
There were times that during arguments, he would tell me to fuck off, he would call me a bitch.
Did he ever refer to you as a during arguments?
Yes, he did.
And in what capacity?
That I was acting like and doing things that do in an argument.
How far into your relationship was that?
That was before we got married. So
Which was?
about 2-3 years.
Is he quick to lose his temper?
Yes.
What sort of things would set you?
Most things would have to do with, and then on top of it, just if there was any type of adversity or something that he felt like someone did him wrong, it would really upset him, and there are times he cut people out of his life because they didn't agree with him or they challenged him.
Did you ever believe that Mr. passed out from drinking or smoking?
Yes.
How often?
On his binges, that would be a regular occurrence. Outside of that, probably maybe once a week, once every other week.
Did Mr. in conversations with Mr. Smith, like texts, etc., did he demand immediate responses?
Repeat that again, sorry.
What was that? Oh, sorry, did I say Mr. Smith? I'm so sorry, I didn't realize I said that. During, with respect to text conversations, did Mr. Demand immediate responses?
There would be times if I didn't text him back soon, I would get another text message that said, why aren't you responding? And a lot of times it was I was at work and wasn't capable of texting. It wasn't all the time, but it did happen.
And how did that make you feel?
To me, it was uncalled for. He knew I was at work, and I would always text back as soon as I was at a point where I was able to do so.
Did you have any concern about in Mr. care?
If there were times where he was drinking excessively, absolutely, and then obviously knowing from how frequently he smoked weed, my assumption was when I was at work and out, not at home, is that was still occurring, was in our care.
And then how did that become, other than just being drunk, how did that make you feel that there was a concern?
Well, because if there was any type of an emergency or anything, he wouldn't be in a condition to be able to drive.
When you are in Mr. Catherine, do you recall that attended elementary school?
Yes.
What was, do you have an opinion of the staff and elementary school in general?
Yes, he wanted to go to the South Reno School District, and when he ended up going, was not happy. Obviously, drive time, things of that nature, dropping him off. And then I know that he had an extreme dislike for the principal, and I believe the assistant principal and the nurse at the school.
And how do you know that?
There was an incident that happened, I can't remember what grade it was in, first or second grade, where it's my understanding he lost his temper with the nurse.
Objection, sounds like not personal knowledge.
Starty Cooper?
How do you have knowledge of that?
He told me, I just don't recall all of the details.
Mr. King, do you wish to have anything else for the record? Then the objection is withdrawn. Go ahead, Ms. Hardy.
Okay. And so based on what Mr. told you, how did he feel about that nurse?
He did not like her at all.
Can you tell me more?
Him, every time that there would be any interaction with any of the staff, the office staff, nurse included, outside after that incident, it would upset him.
Okay. And then so that you testified that happened early in start at that school. How long did Mr. continue to talk about that?
I don't recall.
Okay, did he have those opinions of the school when he was in later grades?
Oh yes, up until the point where we got a divorce and I moved out, he absolutely was still not happy.
How often would you talk about it?
I would say probably every week we had one time, maybe more.
How did you guys break up?
He had a casual sexual relationship with two different men.
Okay. Let's switch gears to, you had a dog named Molly, is that correct?
Yep.
She's no longer with you, is that right?
No, she's not.
Okay. Did Molly live with you and Mr.
Yes, she was.
Was there a situation involving Molly and when he was little?
Yes.
Will you tell us what that was?
Yeah, there was an incident where he was young, had pulled at her whiskers, and obviously as a dog it startled her, and so she nipped at him and she did bite him. Did not leave a mark or anything of that nature, but was really upset about that. And when that happened, he made me put Molly outside and had her sleep outside for the night.
Was that a safe location for Molly?
It was at least fenced, but there's wild animals, there's other things.
What kind of dog is Molly?
A miniature Australian Shepherd,
How much did you weigh? She weighed approximately?
15 pounds.
Is that something that was typical, that you would leave Molly outside
No.
overnight?
Absolutely not,
So why was Molly outside that night?
because he made her go outside and I was afraid to push back.
And so that was a punishment? Was Molly afraid of?
Yes.
How did she react?
There were times where she 100% would just take a step back. She almost like she was startled by him. There were times that she loved him as well, but I noticed that, and then once I had left the home, and she had met other friends that were males, once I moved back to Oregon, her initial response to them was a little bit skittish.
Was she that way before she met?
No.
No. Was there another time when the dog was left outside? Do you recall?
Not
What dog named Nola?
Nola, she was left outside, so came to visit me in June of, gosh,
Let's back up for a second.
yeah, I'm so sorry.
Okay, who is Nola?
Nola was stopped with,
And is that a dog that was after you and Mr.
yes,
Okay. Okay, so now that dog died, correct?
yes.
Okay, so how are you aware of that?
In June, I think it was 21, up to visit me for a week for the first time by himself, and so I was planning on picking him up from the airport. And that morning, on my way to the airport, called me to let me know that there had been a tragedy, and that his dog had been killed. And I went in, brought him back out to my car in the parking garage at the airport, and we called, FaceTimed, and she was able to break the news, and he was obviously devastated, completely heartbroken.
And then were you also present for a call between you and Mr.
I was.
Okay. And then how did Mr. appear? Sorry.
He appeared to be inebriated. He was definitely intoxicated. He was apologetic to the strangest part I think about that whole conversation is that almost consoling him versus the other way around, which to me was very odd. The parent should, in my mind, be consoling the child, and really concerned about his feelings and where he was at.
And do you know how Nola was killed?
It's my understanding she was left, based on the conversation, that she was left outside overnight and was killed by a wild animal.
Did Mr. take responsibility for his actions with leaving the dog outside?
Yes, yes, he did.
Does, in your experience in your relationship, does Mr. take responsibility for his actions during arguments you have?
No.
Okay. How does he react?
Usually just very, as if he's not at fault. A lot of the arguments we would have, it would get turned around on me as if it was my fault, and that I was always in the wrong. And there was never really any arguments that I can recall where there was anywhere where there was a true apology.
Did Mr. ever threaten to harm himself?
Yes.
Can you give me some examples?
Yeah, there was an argument that we had in 2018, or excuse me, 2018. We were having a conversation about getting divorced, and at that point, we didn't file and didn't get a divorce then. But when we were talking about the fact that we may get a divorce and I would leave, that he would be really upset and would potentially harm himself.
Did he describe how he would harm himself?
No.
Has he ever threatened suicide?
No, but there have been times where, just based on either text conversations or verbal conversations, that the thought crossed my mind, especially back in, I think it was 2012, like September, October, when there was a TPO issued against me at that time in regards to and I was definitely concerned that was going to potentially happen.
Okay. Was Mr. jealous during your relationship?
Yes.
Okay, can you give me some examples?
Once we started our divorce proceedings, or where I asked for a divorce, he would talk about the fact that, I'll just have, another man right around the corner, and there's going to be another guy. And then at one point during that argument, there was conversation about my former boss, or my boss at the time, but now former boss, where he thought that I was having a relationship with him, of which I was not.
Okay. Did he ever accuse you of faking orgasms during sex?
Yes.
After divorce, did you maintain a relationship with him?
No.
Did you change your number?
No, but I blocked his number.
Sounds like things were difficult for a period of time. When did you say that he had gone outside the marriage?
I discovered it shortly after we got married in 2016, but it had been happening prior to that. I didn't go back in my text string of messages far enough to.
Did he acknowledge that that happened?
Yes, he did.
And so then you divorced, it sounds like about 3 years later?
June
is
of
that right?
2019.
Okay, so why'd you stay after all that?
Many reasons. Obviously, number one was I loved death, and I knew that his life at Dad's house was better with me there. And then also from a job perspective at the time, the position that I was in, I was kind of trapped in Reno and was struggling to find another role within the same company for a bit of time that would allow me to leave.
After divorce, did you maintain a relationship with,
I did.
can you describe the relationship?
I have still been able to remain close. We text on a regular basis. We FaceTime on a regular basis. I come up a couple of times since I've been in Oregon to come and see me, and then also over the last couple of summers has come up for about a week to come and see me as well.
And then
And
did
I've
Mr.
come down here.
Sorry about that.
Yeah.
Did Mr. object to that relationship?
Yes.
Have you noticed anything different about when he's with his mom versus his dad?
When he's with his mom, I mean, he's just very, he's always a super loving, super great kid. But when he's with his mom, he seems less stressed. He just seems like he's happier.
And what do you mean by that?
That he doesn't really watch what he says. It doesn't feel like it from my perspective that he watches what he says as much as he did when I was living with him versus what I've experienced being.
Okay. Were you aware of whether he was reporting on anything at his mom's house while you were together?
Not that.
Okay, no further questions.
Mr. Kim, 1033.
Yes, thank you. I think you testified a little bit ago that you got divorced in 2019.
Correct.
When did you stop living at the same address?
The day I moved out of Oregon, so I think it was June 15th of 2019.
Okay, so the middle of the year. All right. Did you ever make a complaint to anyone regarding, say, like a social services type agency regarding the parenting of my client?
No.
Did you ever make a complaint of any kind of alleged animal cruelty or anything like that?
No, I did not.
Okay. Now, if I took my notes correctly, you met in 2012, began living together in 2013, and then what year did you get married?
2016.
2016?
16, yeah.
Okay. Are you familiar with having become physically disabled?
Yes.
Okay. Did that occur during the years that you were with him?
Yes.
Okay. And does that tie in anywhere close in time to when there was a prior order going to week on, week off custody?
It might have been, I feel like that was maybe 2013, 2014. I don't totally recall, I'm sorry.
Okay. So were you in the picture when the visitation was only a couple of days a
Yes,
week?
I was.
And then later when it was week on, week
Yes.
off? And then I understand you don't have children of your own.
I don't.
I have no questions.
Redirect, Ms. Hardy Cooper.
I have one question. Did Mr. ever express that he wanted this?
Yes, you
No further questions.
Is the witness excused?
Yes, sir.
Is the witness relieved of her subpoena?
She is.
Ms. Perkins, you are excused and you're relieved of your subpoena, so you're welcome to leave. You don't have to stay at the courthouse for the next 2.5 days. Please do not discuss your testimony with anyone, including the parties, until after the close of trial on Thursday at 5 p.m. Okay, thank you very much, ma'am. Council, we got a late start this morning. I'm happy to take your morning recess now shortly and then the lunch hour, or we can just keep going through and only take a lunch hour today. It's your leisure.
We were going to ask for a comfort break anyway, so
Okay.
we don't have that.
And then to Deputy Rivera, someone was excused for using a cell phone. We'll print a sign. I believe it was a young woman in a light yellow top. If you can find her and let her know. She's welcome to come back in now. Just make sure that the cell phones are not in use. But she was removed only for that one short period of time, but she's welcome back into the courtroom. All right, we'll take a 10-minute comfort break. I'll see everybody back here at 11:10. And please remember that during breaks and recesses, no recording. Thank you all.
All rise. Court is again in session.
Thank you. Please be seated. All right, Ms. Hardy Cooper, who would you like to call as the next witness? 11:09.
Your Honor, we'll be calling, and so this, in conjunction with your order, the first part of the testimony will be, what is excluded regarding this.
The first portion of the testimony is closed, so in accordance with the rules, only the limited scope of the questions may be asked. So just to remind both counsel, the closure will take place. She'll be asked only those limited questions, your right to cross, your right to redirect. Then court will be back in session in an open session. Everything other than that very narrow scope then is in a public session.
And to be specific, Your Honor, we're talking about the physical.
Allegations of the
Domestic-
physical
yeah.
domestic violence allegations, that's the only thing that's the closed. All right.
Manipulation that's happening at the same time. So what we propose is that most of that is occurring during the marriage, during her pregnancy, and during the marriage. And then there's a whole different section of things that happen after the marriage. So what we would propose is that we close the hearing for the things that are happening during the marriage, so at least it can make sense in the testimony, and then reopen for things that are happening after.
That would be more expansive than what the prior order allowed for, pardon me, that would make more open than what my order had. My order closed the domestic violence, including the new incidents, because it went to the intimidation issue. But given the withdrawal, I'll narrow it to only during the marriage will be closed, and then everything that's happened after comes back into the public session. Any objection, Mr. King?
So are we using the date of the decree?
Date of the decree.
Your Honor, I'm sorry, I think I was talking to my client, I'm not sure I heard your summary of what you just said, sorry about that.
The closure,
Yeah.
according to Ms. then is as to only the period of time before the date of divorce, or up to the date of divorce. So that's slightly more narrow.
Oh wait, so I guess I misinterpreted what you were ruling before. So I thought that, I wasn't aware that you were willing to close the future intimidation domestic violence. If that's the case,
If
then that
there's-
changes us.
If there's specific acts, that's what the order was, but it's very, very narrow. So the request today to keep it clean makes sense. So it will be through the date of divorce only, and then everything else will be in the public session. All right, then we move into a closed session pursuant to the order. All right, are we going into closed session now?
Yes, Your Honor.
All right, I'm so sorry to the members of the public. Go ahead and have a seat out in the lobby. Thank you very much. To our observers, that is the only portion of the proceedings that have been closed over the next 2.5 days. I don't believe that any other portion has been closed pursuant to an order. Everything else should remain public at this time. Counsel, you had asked, and my law clerk has now double checked, the hearing where we set trial at approximately 4:37 p.m., I asked counsel how long each party wanted for their trial. Mr. said he could finish a trial in one day. Ms. requested 3. So based upon that, the time would not be equal. There was a 1/3 request. Mr. King was certain that he could be done in far less time. I afforded Ms. additional time because she believed that she needed it for her witnesses, so I didn't truncate the trial down to the one day that Mr. asked for. But then to give you more time than what you ever requested would be patently unfair. So at this time, it would be the equivalent of 1 day to Mr. King and the equivalent of 3 days to Ms. Now, I say that if I believe that Mr. King and his client are prejudiced or something like that by witnesses that weren't disclosed, or that you need slightly more time than 1 day, I will absolutely consider that. But at this point, Ms. Hardy Cooper specifically noted her intent and need for additional time, and the court granted it when it was scheduled.
I'm sorry, but the court's misinterpreting my intent of my remarks. I mean, it was going to be a 1-day hearing with half on each side, or a 3-day hearing with half on each side. And there was no intent to try to say that, oh yeah, we only want a day, because all the stuff going on, we're going to need whatever time we need to respond. And I don't think it's fair to say that they get 2/3 of the time.
Well, the case law from the courts would disagree. As I said, Mr. King, you have disclosed no witnesses at any point. You have disclosed no exhibits at any point. The burden of proof for this motion, if Ms. cannot meet the burden of proof, her motion falls. She has the burden of proof. If the burden of proof were on your side to defend, I would absolutely reconsider the time ruling, and I will personally go back and review, because I've had someone else do it for me. This is from the hearing February 20th, 2024. 4:37 p.m. is when we discussed how much time was going to be needed. I agree with you that when you said it was 1-day trial, that means that you thought you could be done in 3 hours or less. I'm not going to hold you to 3 hours. I would give you twice that time of what you asked for. But I wouldn't say that you just get half, even though you didn't ask for that time at the time of the setting. So I'll go back and look at it, and if we have further argument, I'll entertain it in the morning. But that is the hearing. If you do wish to go back and look at it, that is the hearing where I found the material. All right. Who would you like to call as your next witness, Ms. Hardy Cooper?
We'll call
Ms. You're now taking the stand with regard to all of the public material. You remain under oath. Go ahead and have a seat. At this time, counsel, the exhibits in evidence are only 2 and 3. No other exhibits are yet in evidence at that time. If that doesn't match anybody's records, please let me know. No, it isn't. The entirety of Exhibit 2 is in evidence. The entirety of Exhibit 3 is in evidence, not certain pages. They were offered into evidence at 11:50 a.m. Go ahead.
Thank you. You provided us text between you and Mr. From April 24, 2010 to February 5th, 2024, correct?
That is correct.
Did you delete any text during that range?
No.
Will you please open the exhibit finder and look at exhibits 3 through 6? Oh, sorry. Did you say 3 was already in? 4 through 6?
2 and 3 came in at 11:50 a.m.
Thank you. Starting at exhibit 4 and through exhibit 6. Okay. Who are these text messages between?
Text messages from me are in the green on the right, and text messages from Mr. on the left.
Okay. And did you use the iMazing program to pull the text from your phone onto a transcript?
Yes, I did.
Is this an accurate reflection of the text that were on your phone?
Yes.
And then exhibits 4 through 6 are excerpts from that big packet of exhibits you provided us, correct?
Yes.
Your Honor, I move to admit exhibits 4 through 6.
Mr. King,
Can I have a spoon?
take your time.
Objection.
Exhibits 4, 5, and 6 are deemed admitted. 225.
Did the sexual and physical violence continue after you were divorced?
No.
Did you feel that there was still a continuation of domestic violence after you were divorced?
Yes.
Make sure you're speaking up. Okay. Was there a time in 2012 when Mr. received a call from one of your friends?
Accidentally, yes.
Okay, and who was that from?
It was two friends, a married couple, and it was from the husband's phone.
And then how did Mr.
He reacted terribly. He made accusations against the friend and against me.
Will you turn to page 2 of that exhibit,
Which exhibit?
or on exhibit 4?
Yes, pages 1 and 2.
Right. So on page 2, what were you doing?
I was proving to him that his theory around the phone call that was made to him as being inappropriate was not true, and I was proving that the delusion he was having was not real.
What delusion was he having?
He didn't believe that it was my friend's husband that was calling me. He believed it was somebody else, I don't know who. And I was showing him my phone history to show that they had called me immediately after because they realized they had called accidentally when they meant to call me.
Why did you make such an effort to prove to him who it was calling?
Because there was still so much control happening in our relationship, and I'm very fearful of him at this time.
At the time that was, sorry, at the time that was happening, how old was
At this point, it would have been maybe not quite 3, 2, just 2 years old.
Okay.
Well, maybe
Yes,
about a year and
actually-
a half.
It was actually, according to the exhibit, February 18th, 2012. So would that make him just under 2 or a year and a half?
Yeah, about a year and a half.
I refer you to exhibit 5. We're now at June in 2012. You've been divorced for approximately 7 months. How is Mr. communicating with you during this time?
At this time, he is trying to restart the relationship.
And how did he do that?
He did that through persistently sending me messages and then phone calls and telling me, like, you never deserved any of that. I feel so ashamed. I did that to someone I love so much. I know that you are scared, and I understand that. Scared that there is a chance it would fall back to the bad times.
During this time, does he refer to himself as bad or old?
Yes, he does. Old is meant as the good that he believes he was at an earlier point in the relationship, and bad is when abuse occurred.
There's a break in your message on the same page 1. We're looking at June 12th at 8:20 a.m. You respond at 9:36, and you say, "I'm sorry it's taking me so long to respond." Why did you feel the need to say that when it had only been an hour and 15, 16 minutes?
I still felt incredibly controlled by him, and if I didn't respond to him, he would become very upset with me.
Over the course of that summer, was he continuing to get you back, try to get you back?
Yes, constantly.
Did you let him know what your feelings were on that?
Yes, I did.
How so?
I would text him, I would express to him that it was time for us to move on from anything that had occurred. I would also tell him that in person and then also on the phone.
And how did he respond to that?
Very poorly.
Can you give me some examples?
He would yell at me, he would swear at me. He would tell me that I wasn't being fair. He would tell me that I was ruining our son's life.
Did he ever threaten to kill himself?
Yes, he did on multiple occasions.
Did he threaten to harm himself short of killing himself?
Absolutely, yes.
And that's during this time frame covered in Exhibit 5?
Yes, and I believe we have texts that also show that too.
Objection, none, response to the motion, strike.
Overruled.
How long did that continue with him trying to get you back for the summer?
That continued all the way through the summer and into the early fall. And the threat of him killing himself became a more frequent tactic in trying to get me to get back with him. And we would talk on the phone, and he would tell me that he had a live gun with him, and that if I didn't get back to him, he was going to blow his head off. So that the last thing I heard was him killing himself.
Where did he live during that summer?
Mr. purchased a home directly down the street from where I lived.
Did you have to go past his house in order to get out of the neighborhood?
To get to my house and to get back from my house, I had to drive past his house.
And when did he purchase that home?
At the time of our separation,
And you were already living there?
I was already living in my home. He chose to buy that home.
Was he watching your home?
Yes,
How do you know?
he would tell me.
And can you give me some examples of how he told you?
I have text messages that show that he was watching me, and he also told me verbally and then on the phone. He would watch people coming and going, and he would text me and tell me he knew when people were at my house.
At that point, had you started dating someone?
Very casually, I started dating, maybe around late spring, early summer of 2012.
And did Mr. want you about dating that person?
Yes, that was later, into the late summer, early fall of 2012, yes.
Okay.
Although those were different people. Am I allowed to clarify?
I'll ask you, was there more than one person you had casually dated?
Conversations I was having, dated might even be a little bit strong, but just meeting people for coffee, it was much more casual than that.
Did he know about the person or people you met for coffee?
Yes, on the phone he would tell me after I came back from a coffee meetup that he knew where I was, and he told me that people were watching me and reporting back to him.
Okay. Can you move to page 12 of Exhibit 5, please?
Exhibit 5, page
Exhibit 5,
12.
page 12. And I'm going to reference the timestamp of July 9th, 2012. You say that at 12:14 p.m.?
Yes,
Okay. And is this an example of Mr. confronting you about someone you're seeing?
yes it is.
At this point, is this someone for coffee or someone different?
I believe that this was someone that I was casually dating.
That person that you were casually dating, did Mr. focus more and more on that person?
Yes, absolutely.
Can you tell me how?
Mr. was absolutely obsessed about where I was, who was watching while I was out on dates, whether they were real or imagined, because he often thought I was on dates that I was not actually on a date with. And then it escalated to the point where he alleged that he was going to be killed and that he himself was going to be killed by this man that I was very casually seeing. Because he was able to watch this man drive to my home and drive away from my home.
To your knowledge, did Mr. have any verbal communication with this person?
No.
I would guide you to page 14, same exhibit. On September 6th, 2012, at 6:38 p.m., what's happening there?
This is him watching for this gentleman leaving my house and alleging that the man gave him a look that he did not like.
Did you try to set boundaries with Mr.?
Constantly, yes.
What are some examples of the boundaries you tried to set?
I would text message him and also in verbal conversations and in-person conversations tell him that this behavior was unhealthy, that we had made the decision to separate, that I didn't want him to hurt anymore, I didn't want to hurt anymore, and it was in our best interest to move on and both be happy for the benefit of our son and then also for ourselves individually.
How did you respond to when he is claiming that this man was aggressive with him?
I responded with the truth, which was that this was not real, that this was an absolute delusion and had never even happened. His story, Mr. allegations began with a look, and then the same story kept escalating with new retellings of it. And in the text messages, it starts with just a look, and then it escalates to him allegedly sticking his head out, and then there were gestures, and this was all over the course of weeks. The same incident was retold at grander and grander levels. And I told him, and I believe it's reflected in the text messages, that I did not appreciate this, and that I took safety very seriously, and I would not be exposing anyone, having them be alone with any other person, which I never even met any of these people and was not around them for a good portion of time. And this gentleman, and I told this was unhelpful and it felt very attacking to be making these allegations against me. And I tried to de-escalate it constantly. I tried to tell him that this was just a misunderstanding. I tried to tell him that this wasn't real, which was very common behavior by me with trying to de-escalate Mr. and just trying to reinforce that this wasn't real, it was just a misunderstanding, and that it's a non-issue.
And there's examples of that over the next few pages of Exhibit 5, correct, from page 14, continuing on to page 17.
Yes, I wrote him, I'm sorry you feel something happened, and while I agree it may have been awkward or ill-timed, I promise you there was no rude intent, and there's nothing to be concerned about with. And then I go on to say, I feel the need to be very clear here, and always will always be fine. His interests are the most important thing to me. Nothing that happened or you think happened affects him. And this part of our conversation tonight is over, and that's an example of me trying to set boundaries because I did not want this situation to continue to spiral because there was a lot of obsessiveness with staying on the same topic, and I was closing the topic.
Did Mr. allege that there was any other incident other than the one where they drove past each other?
No.
We turn to page 17, please. At some point, did, well, I can ask you this without looking at that right away, but at some point, did Mr. change his communications with you to perceive, to actually be threatening towards that person?
Absolutely, yes.
Can you tell me what your memory is about that?
My memory of that, or what happened, was that he then, Mr. escalated this as death threats against him, and that he needed to have his gun on him, he needed to be outside with a gun to protect himself, to potentially kill or harm this other person.
Around the same time, did Mr., and this would be September of 2012, did Mr. ask you the address where you were working?
Yes, he did.
And did you provide it?
Under duress, yes.
What do you mean by that?
He had told me that publicly humiliating me and coming to my workplace to embarrass me was something that he threatened to do constantly, and he didn't have my work address because this was after our divorce, and I was very, very nervous about him coming and making good on the multiple threats to come to my workplace and to embarrass me.
Is page 18 of Exhibit 5 that conversation?
Page 18 and page 19.
In that, he says that he needs that information immediately and especially by 5 p.m., is that right?
That is correct.
And then you asked him why he'd want that?
Correct.
Did he answer that question?
No.
What did you think that meant?
I thought that meant that he was going
Objection,
to.
call for speculation.
What did it mean to you?
It meant to
One
me.
moment.
No.
Any further argument, Mr. King?
Same objection.
Why would it be the same objection, given that she's now asking how this person took the comment, not for the truth of the matter asserted?
Well, she's just speculating. I mean, it's,
How she took it, not for what she believes it was intended.
well, if it's how she took it, then it's irrelevant.
Ms. Freddie Cooper as to relevancy?
Your Honor, it goes to our argument about the ongoing domestic violence that's occurred over the years, and this is an example of the intimidation that Ms. put upon Ms.
Any further offer of proof or argument, Mr. King?
You know,
All right, as to relevance, the objection is overruled. Go ahead and answer, Ms. How did you take it? Not opining as to what you think Mr. intended it for.
Yes, Your Honor. I took it as him making good on his threats to publicly humiliate me at my workplace.
And had he made threats at your workplace before?
At previous employers, yes, this was a constant element of the emotional and psychological abuse that was happening.
Was this related to releasing the letter?
Yes,
And then what does it mean when he releases the letter?
that he's going to
What
kill
did you
me.
take it to mean?
I took it the way that he told me, which is that he was going to kill me.
Did your conversation with Mr. regarding your friend that you drove by continue on through September?
Yes, it did.
Okay. How did it, on September 18th, let's switch you to page 21 of your exhibit. Appears to be at 9:19, September 19th, 2012 at 3:24 p.m. He says, I still have B, you can come by around 5 and get him. What had happened that day?
One moment, please. This was a very hard day. Mr. was supposed to be on shift that day. He was supposed to have gone into work in the morning, and he was supposed to bring, per our custody agreement, to his childcare location, his daycare. And I called the daycare to check in on. I found out that he had not been brought to the daycare. That's where the text trail began, and told me that he had kept that day. I was supposed to pick up at the end of my normal work shift, although technically I had custody of him as soon as that morning, because again, he was supposed to be at daycare. And then we began a text trail that began to escalate considerably into delusions and beliefs that he was about to be murdered as well as about to be murdered.
So he said that exactly?
Yes, he did. He said that he would be killed and he was going to be killed by the same gentleman.
Are you referring to on page, is this memorialized on page 22 where Mr. says you're trying to pick him up at 4, he's saying that he's not going to give him to you till 5, and then you said, I was not asked to change the schedule and I'm confident you would be upset if I did the same thing. He responds, I would be upset because B would be with your killer boyfriend. I won't be home until 5. Please tell him not to kill me. Please let me know when you're on your way to get B. Now, is there any indication that your boyfriend was a killer?
No, definitely not. I wasn't even seeing him, and the relationship never even escalated to the point of being a boyfriend, but I was no longer even seeing him at this point.
How did you feel when you got those messages?
I was terrified, having seen spiral on so many occasions beforehand, and then also some of the phrasing and terminology that he uses, along with the fact that he was supposed to be on shift that day. I suspected he was drinking and was drunk, and that was confirmed when I showed up to the home.
Objection, calls for speculation.
Overruled. She's testified that it's her basis of knowledge, based on the text messages, that she suspected he was drunk. How is that speculative?
She was describing a phone call.
She's describing text messages, actually. Based on the language used, the weight, remember, counsel, the weight that the court affords something is completely different than a disability. So it may or may not be weighed very heavily, but as to admissibility, the objection's overruled. I'm sorry, so the answer stands. Go ahead, Ms. Stewart.
Did you arrive at Mr. House's pickup?
Yes, I did.
Okay, and what happened when you went in?
I came up to the door. Mr. cracked open the door a few inches and immediately started yelling that he was in danger and that he would be killed and he didn't want to be killed. And then I said, it's time for me to take. He was absolutely terrified, absolutely terrified. His voice was all over the place. He was slurring his words. He was in a complete manic state from my perspective, talking about being murdered, not wanting to be murdered. And I saw, and then at one point, again, the door was only cracked just a few inches maybe, or maybe a foot, maybe more than a few inches, but just a very small degree. And I was looking around the door and I could tell that he didn't have a shirt on. And then at some point while this was all happening, he stepped away from the door and was just a couple feet away, crying, sobbing on the other side of this while this was happening. And then while Mr. stepped away, I had him towards me and I grabbed him and I went running to my car. And while I was putting him in the car to escape the situation, he came out in his underwear, screaming in his demon voice in his front yard, "Why are you leaving? I don't want to die," completely out of his mind, drunk and screaming in his underwear.
After that, did you apply for a temporary protection order?
I did, and that was also after a very disturbing phone call that had happened that night.
What was the phone call?
The text messages also reflect that too. Am I allowed to refer to the text messages?
Objection, non-responsive, motion to strike.
Sustained.
Tell us what happened in the phone call.
What happened in the phone call is immediately after that, I did not return to my house. I went to a safe location and I contacted my parents. And I believe I also reached out to you. And then only until I had a safe person with me that could provide me protection did I go back to my home and reached out and wanted to speak to. And I agreed for that conversation to happen because he said that he wanted to say goodnight or he wanted to say hi. And the phone call happened on speakerphone with me and the other person that I was with. And immediately started screaming, and I could tell he was still drunk. He presented to me as still deeply, deeply inebriated and started screaming, "You're going to be killed, don't let him be killed, he's going to die." And I hung up the phone on him. I said goodbye. I did say goodbye, and then I hung up the phone on him.
Okay. And then your text messages on page 23, is that what you're referring to? You said that you had text messages about the issue too?
Yes, that's correct.
Okay. And then thereafter, you applied for and obtained a temporary protection order in this court?
Yes.
Your Honor, I'd ask you to take judicial notice of that case. I don't have the case number handy, but I can get it to you next time.
Mr. King?
I don't have any objection.
Court will take judicial notice of the related temporary protective order action.
We'll now be talking about Exhibit 6, not just yet, but was there a time that, one moment please. Was Mr. So I'll, oh, sorry, this, I'm sorry. Okay. Did Mr. marry?
Yes, he did.
Did you have any relationship with her during the marriage?
Barely no relationship, no.
And then after, how long were they married?
I don't know exactly how long they were married, but I know that they were together between 2012 to 2019,
When
7 years.
they divorced,
Acted very devastating. He was devastated.
was he close with his stepmother?
He was very close with his stepmother. He loved her very much.
Did he want to continue having a relationship with his stepmother after the divorce?
Yes, he did.
And then was supportive of that relationship?
He was in the beginning.
Okay, and then what happened?
And then he became very upset in the continuation of the relationship, particularly when he found out he wasn't going to get access to Lindsay's home address.
Did things change between you and Mr. after they divorced?
Yes.
What are some examples of that change?
After the divorce, I found him during the time he was with Lindsay to be a calmer time. It was my understanding that Mr. was getting mental health support, was on medication, and was working through his issues. And so I was supportive of that in the pursuit of his mental health. And then that changed following his divorce from Lindsay.
So other than it being not calm, are there any specifics that changed?
There was still a lot of conflict in the relationship. It was still a high conflict co-parenting relationship, but the outward signs of the threats towards me and the threat of killing me subsided during that time when he was married with Lindsay, but it was still very high conflict. And there were also examples during that time of, like for example, when I became engaged, that was very enraging to Mr. And he was furious and enraged.
How did he express that rage?
He yelled at me in an in-person conversation that I was finally marrying a man that was everything that he wasn't, and that he believed I chose my current husband just to spite him, and that my second marriage was about making him angry. And then he also made child abuse allegations against my fiance at the time.
What did he say?
He said that he believed that he was being hit and spit on and hurt, and that he was going to be going to Child Protective Services to file a complaint.
And how did you respond to him?
I told him that at that point, and my current husband had actually never been alone, which was absolutely the truth to that point, and so that none of this was real.
And then did Mr. Any child abuse claims to any official source?
No, he didn't.
And then when did you get married to your current husband?
We were married in April 2014.
Okay. When Mr. and Ms. Perkins were together, did Mr. to his sporting events?
When Mr. was married to Lindsay, he took him to sporting events, and he was also a youth coach for the season while he was with Lindsay.
Okay, moving on in the exhibits, we're gonna start talking about the Our Family Wizard exhibits. Are you in the order to use Our Family Wizard for non-emergent communication?
Yes, we are.
How often are you to sign on?
Every other day at minimum.
And then are you ordered to respond within a certain amount of time?
Yes, within 24 hours.
Okay, have you granted me professional access to review your messages?
Yes, I have.
Are exhibits 7 through 19, some of those messages?
Am I allowed to look at the book again? Exhibit 7 through,
19?
yes, they are.
And you directed me to some of these messages, is that correct?
That is correct.
Before we submitted them as exhibits, did you verify that they were accurate representations of the Family Wizard messages?
Yes, I did.
Your Honor, I'd move to admit exhibits 7 through 19.
Mr. King?
Your Honor, there's about 20 pages to go through. Can we have just a minute here before our review break?
You want to take your afternoon break now?
Sure.
Council, how long would you like for your afternoon break in order to give yourself a comfort break and review those documents?
Fine.
Since I don't want to take another break, I mean, members of the public can come in and out as long as it's not distracting, but why don't we take a little bit longer break and then try to go through straight to 5 just to be able to finish? So why don't we come back about 10 minutes after 3, and then unless there's a specific request for a break thereafter, I plan on going until 5.
Okay.
Okay, I'll see everybody back here at 3:10, please.
All rise.
Thank you.